All right. With that, we'll get started at seeing it's 1:30. Thanks all for joining us. My name is Eric Hauge, Executive Director of Homeline, and you're joining us on Wednesday, July 15th in the afternoon at 1:30 for another one of our weekly webinars on tenant, landlord, and rental housing related issues during the COVID-19 pandemic. We have been doing these every week since approximately mid-April. And again, this week we are doing just one session for all audiences, both tenants, service providers, and landlords. And today we have with us both Homeline's managing attorney and tenant hotline director, Mike Vraw. We also have a special guest who will be sharing more during this session. 4th Judicial District Housing Court referee, Melissa Houghtaling, is joining us. And we'll be discussing some of the plans in Hennepin County courts around what is currently happening with cases, housing related cases, and a look to the future as well. Just a reminder, Homeline is a statewide nonprofit organization. Our main program is a free and confidential legal hotline that any renter can call and get legal advice in 4 different languages: English, Spanish, Somali, and Hmong languages. Again, today we're doing a longer session, 90 minutes, just one, instead of breaking into 2 webinars, which we had been doing in previous weeks, a Wednesday tenant and service provider focused one and a Thursday landlord one. Again, next week we're going to do the same thing, just one session up to 90 minutes. It may not go that long, but since there's been a number of new updates on what is going on in Minnesota as far as the eviction suspension, we're going to go into the details of that. And so with that, what I'll do is I'll first pass it over to Homeline's managing attorney and hotline director, Mike Vraw, to just briefly cover the most relevant updates, and then we'll move on to referee Houghtaling.
Thanks, Eric. If you could turn the page for me. Thank you very much. So, quick recap of where we are and actually some new information. To start, the peacetime emergency declaration was renewed once again. Officially, I guess that would have been Monday of this week, a couple days ago. So the peacetime emergency declaration, which is essentially tied to the eviction moratorium, is extended now through August 12th of 2020. Last week at this time, although we suspected that would happen, we weren't certain that it would happen, but it's been declared officially. Either the governor or the legislature could end the peacetime emergency, but the legislature, if they wish to do that, both chambers of the Minnesota legislature would have to vote to do so. The Senate has voted to end it, the House has not, and it looks unlikely that this will end unless there's some sort of agreement, might be a grand agreement between the legislative and executive branch at some point on a lot of moving parts, not just evictions. So anyhow, that is in place through August 12th. That's the first question that we always try to answer, is where's the Minnesota moratorium at? The new news, and how new is it? Well, last night at about 6 o'clock, referee Houghtaling very kindly sent over some slides for her PowerPoint presentation, and I had to email her back almost immediately saying, do you want to update it? Because there's new rules, which is actually why we're doing these on a weekly basis. The rules are changing amazingly fast for our line of work. Normally laws take weeks, months, years, sometimes decades before they actually go from an idea for a law to eventually being a law. But now, since COVID-19, the change in our line of work has happened so quickly, so often, that we are doing these presentations to try to keep people informed. We're going to go in depth to cover what the new order changes. The good news, I guess, from this speech's perspective is those changes don't take effect until August 4th, which is not how it's been normally done. Normally, it's been an immediate announcement with eviction information, and that implements or is implemented right away. This isn't going to take effect till August 4th, so we're going to give a long, like I said, 90-minute version about what the changes mean, the August 4th changes next week. Referee Houghtaling is going to touch on them today, but we've got other issues that we're talking about that are still in place. Additionally, we still have our federal prohibition. The CARES Act bans non-payment of rent evictions through July 25th, but then the landlord has to give a 30-day notice, so it's effectively through late August. But that's not every landlord/rental property in the state. It's probably 20 to 50%. Those of you that have been watching have seen how we've sort of figured that out. If there's any kind of public subsidy, chances are very good the CARES Act will cover that. Also, a landlord who has a mortgage that is federally backed, like Fannie Mae or Freddie Mac, would be bound by the CARES Act. So anyhow, those are our two hurdles that landlords still have to get past. There's a whole bunch of other issues to consider when it comes to landlord-tenant law in Minnesota right now, but the eviction moratorium is really the big elephant in the room that we're all still working with, because that's such a radical change from our normal MO. Okay, let's go on to the next page, and I'm going to just briefly introduce referee Houghtaling. And I noticed that she pointed out that she started in January 2018, or I'm sorry, when did you start as a housing court referee Houghtaling? When did that happen?
January 2018, that's correct.
January 2018, okay. And she's been assigned to the civil and criminal divisions handling housing, harassment, expungement, and petty misdemeanor matters. Prior to her current spot, she was a human services judge for the Minnesota Department of Human Services, handling appeals related to agency determinations for public benefit programs, MNsure, and administrative maltreatment cases. She's also worked as an appellate attorney for the Minnesota State Tax Court, private practice litigator, a conciliation court referee for the 4th and 2nd Judicial Districts, and a hearing officer for St. Paul Public Housing Agency. She's taught as an adjunct professor at Mitchell-Hamlin School of Law, Hamlin University, and Inver Hills Community College. She's participated as a volunteer at VLN and is a past chair of the St. Paul Human Rights and Equal Economic Opportunity Commission and the Minnesota Lavender Bar Association. So just looking at your past career, you've worn a robe quite a bit.
A little bit, yeah.
Yeah,
Like
different robes.
Yeah, different types of robes, different types of venues, but a robe nonetheless. So
the robes are all the same color, right?
they are, yes.
Okay, okay, fair enough. Well, I'll let you take it away. Thank you again for joining us.
All right, thank you, Mr. Raw. All right, so what I thought we'd do today, we can go ahead and go to the next slide, Mr. Haug. I thought we'd do an overview of the current status of cases and backlogs in Hennepin County. I know that there's been a lot of questions about when are we going to get up and started, what are things going to look like, and what does the backlog currently look like. So I thought we'd look at that. We'll discuss the process of expungements, because those are going to change a little bit for eviction actions. We'll discuss what the court is doing for court safety, a little bit about the post-peacetime emergency resumption plans, little predictions as to what the court is preparing for. And then I created a slide with some resources for landlords and tenants to access, hopefully before you file and before you come to court. You can go to the next slide. So we'll start with the current case status and backlog. Currently, we're scheduling cases in the 4th Judicial District for emergency tenant remedies actions, rent escrow matters, commercial evictions, with the caveat that while we may be entering judgment in favor of the landlord, we are staying the writs of recovery until the lifting of the peacetime emergency. The reason for that is that Governor Walz's orders, whether that be 20-14, 20-73, or the new one, 20-79, has not made a distinction between writs of recovery for commercial properties versus residential properties. And so we are staying the writs of recovery pending the lifting of the peacetime emergency, but we will hear those cases since those have not been placed on suspension. And then we're hearing residential eviction actions where the landlord has alleged a violation of Minnesota Statute 504B.171, or has alleged an exception to Executive Orders 20-14 and 20-73. So what that's requiring of us is each time a complaint is filed in the 4th Judicial District, a referee takes a look at the complaint and makes a determination to say whether yes, schedule a hearing, or no, this does not meet an exception. So the more information that we have in the complaint as to whether it falls into the exception where there's serious endangerment, we can make a determination based on that. What you need to know is that this will remain the process in effect until August, or the lifting of the peacetime emergency, so August 12th. or the lifting of the peacetime emergency, whichever happens first. And then effective August 4th, we have the new executive order that did come out last night. I knew it was too good to be true for me to create a PowerPoint and allow it to be effective for 24 hours. So I did take a look at that today. I appreciate Mike alerting me to it. And now I think the key point to this particular order, it doesn't change a whole lot from the previous orders, aside from now a landlord effective August 4th, a landlord must provide 7 days written notice to the tenant of their intent to file an eviction action. So we have not, as a court, discussed what that's going to look like in terms of how the clerks will accept or reject filings, whether there needs to be an affirmation prior to filing or an affirmation in the complaint that 7 days written notice was given, or whether we will just accept all filings as we have been, and then it will be up to the referee to inquire of the parties once we get to the initial appearance as to whether that 7 day written notice was received.
Referee Houghtaling, a quick question on that 7-day rule. So reading the new order from the governor, it looks to me like that means even for a violation of 504B171 or endangering the safety of others, the landlord would now have to give a 7-day notice, at least on August 4th, which they don't have to do today.
Correct. That's how I read it as well.
Okay.
So I read that as if you want to file an eviction in Minnesota, you've got to give 7 days notice, regardless of the reason for the filing. And, you know, I think that, at least from my perspective, that's not necessarily a bad idea. Because what we see in the courtroom, even with the cases where there's been an allegation of serious endangerment, is that the landlord's attorneys or the landlords are working with tenants to come to some sort of agreement at that initial appearance, whether that be an agreement as to a move out date, agreement as to if there's, say, for example, an unauthorized individual in the property, that they're going to be gone and that the tenant can stay. There's a variety of different agreements that people are reaching. And I think the goal of this particular executive order, if I had a crystal ball, would be to prevent some of the filings and the inundation of the courts of these eviction filings, and perhaps finding resolutions for people before that eviction goes on their record, because the eviction becomes part of a tenant's rental record immediately upon filing.
But there's no question this 7-day rule is absolutely a change from what we had before.
It's a complete change. There's no statute that indicates that this would ever be required from before. But it also allows the tenant to, sometimes tenants don't know that they did something wrong. And the first thing they hear about it is with the eviction summons. And so this gives them a chance to sort of say, hey, I didn't realize I did something wrong, or I didn't realize, you know, my brother or sister did this while they were here at the property. I mean, a variety of things, and maybe work things out by talking about it before it has to escalate to a court action. So from the court's perspective, the more parties can work through things, the better. People tend to be happier if they get to reach an agreement versus if I'm telling them what they have to do. So that's sort of the cases that we're currently scheduling now at the courts. So if you file something and it doesn't qualify as an exception, it's just going to get what we call a pandemic event notation in our document system, and we'll start scheduling those once the peacetime emergency is lifted. All right, so another question that we often get is, how soon will we start hearing things once the peacetime emergency has been lifted? So as of yesterday, we had about 315 eviction cases that were suspended in March and April of this year, or have been filed but do not qualify as an exception to the governor's executive orders. Those will be the first to get scheduled upon resumption of services in eviction matters. So to get through those, it's probably going to take us a couple of weeks. And the reason it will take us a couple of weeks is that, one, we'll need to send out notices to everyone to notice the hearings that will take place. And two, we can no longer have mass calendars So it's just going to take each of the referees a little bit longer to get through each of these cases. What you should also know is that approximately 140 of the cases of those 315 are newly filed. And those have all been filed and found to not be an exception to the executive order. And therefore, it is a violation of Executive Order 20-14 and 20-73 for them to be filed. The court administration does not have the ability to reject filings that come in that meet all of the requirements of any other filing. So there's no restricted identifiers in them. If we receive something, we have to take it in. We are not a prosecuting authority. However, that does not mean you haven't violated the law by filing it. Additionally, court administration can't give legal advice. So if you call the court and you say, my tenant hasn't paid rent, can I file this eviction action? The clerks have been instructed to say, we have to accept any filing that is provided to the court with the appropriate fee. They can't provide legal advice. They can't provide you with any instruction as to how that works, aside from instruction as to how to fill out a form in terms of this is where you put the date or this is where you need to put someone's name.
A couple quick questions about what you said on this slide.
Yep.
Somebody asked, is the 315 just Hennepin County? I assume that's what you're talking about.
That is correct.
Okay. And the other one is the 140 that you mentioned, were those really front loaded, or are people still filing evictions wrong?
People are still filing evictions wrong. I will tell you, on Monday, I reviewed 5 eviction filings, all for non-payment of rent.
Pure non-payment.
Pure non-payment, nothing else, no other allegations.
That is hard to believe, but I guess, why would you lie about that? Yeah, that is just so surprising.
Yeah. So people are still filing them. It's still a violation of the executive orders. And by violation, what I mean that you could potentially be guilty of a misdemeanor and punished by a fine or imprisonment. The Attorney General is the one who is enforcing the executive order. What you should know is that when you are filing cases right now, anything that's not getting scheduled for a hearing is being designated as confidential. So what that means is that if you go to the courthouse and you look up someone's name to see if there's a case against them, it wouldn't show up immediately. It won't show up in the court record until we release that confidential notation, and we'll release the confidential notation when we issue the summons in these cases. So despite court administration accepting a filing, a landlord is still in violation of the moratorium on eviction actions, and the case will most likely be dismissed upon the resumption of hearings. You'll get a hearing date because the tenant has to find out. We're required to provide notice to the parties. So you'll need to provide notice to the tenant that something was filed. You'll come to the hearing, and most likely we will dismiss your case. So if your goal in filing these is to be first in line, or if someone instructed you that that is what is going to happen if you file now, that not only subjects you to potential criminal consequences, but it also is untrue, because we will most likely be dismissing your case and you will have to refile, thereby putting you at the end of the line at that point. You can go to the next slide. All right, so there's been a lot of questions that the court has received related to expungements, because we did suspend expungements for a little while due to the fact that we had previously required in-person appearances for those motions. What we are doing now is that we are going to continue considering requests for eviction expungements, and any expungement motions that have been filed during the time of the peacetime emergency or when court operations were suspended will start to be scheduled. Those are going to be scheduled for what's called an administrative hearing. So you won't be given a time for your eviction hearing. It's essentially giving notice that on a specific date, the court is going to review your motion, review any objections, and make a determination administratively without a hearing. So just based on the papers that are presented to us. So that requires you, if you're going to file an expungement motion, to give us as much information as you can in that motion that you would want us to know about why we should grant your request for an expungement. The only time that we'll be scheduling hearings on expungements are going to be if the non-moving party, who is oftentimes the landlord, if they file an objection. So if the non-moving party files an objection to the expungement motion once they receive notice, then we are going to set those hearings on for a telephone hearing. Again, these hearings will not be in person, they'll be via telephone, and the parties are going to need to notify the court of a phone number to be reached at for the phone hearing. And we will have a phone number set up. It'll all be in the documentation that you receive related to the hearing. And you'll call, you'll most likely leave a message saying, this is my name, this is my case number, I have a hearing on this date, here's the phone number I can be reached at. The requirements for how you file and serve a motion will not change. So the moving party is still required to comply with all of the motion rules. The moving party must still serve the non-moving party and file proof of service before the administrative review will take place. If we don't have proof of service in the court file at the time that we are administratively reviewing, we will presume that the non-moving party did not receive notice, and therefore we will deny your motion, but of course you can always bring it again and provide the appropriate feedback or the appropriate service documents. I have had a number of expungements where I've reviewed administratively, dismissed them because there was no proof of service in the file, where the tenant then filed the proof of service after they received my dismissal. And I have then reviewed those again, knowing that the service did occur prior to the administrative hearing, but we may become less likely to do that as the volume increases. Those have been few and far between, but the onus is really on the moving party to make sure that the non-moving party is served properly.
Would you encourage folks to file an expungement motion now while the eviction moratorium is in place? They might get a hearing quicker.
For sure. So we are scheduling everything we can schedule, everything we can review or issue orders on during this moratorium we are doing. So we're trying to plow through as much as possible so that once the moratorium is lifted, we can really focus on just the onslaught that we're anticipating for eviction cases. So definitely, if you've been meaning to file a motion for expungement or you've been wanting to have your case expunged, get the paperwork to do it, file it. You'll most likely, you'll get this notice of administrative hearing, which is not an appearance, it's just a review of the file. And then you will
Eric, did we lose the referee sound?
Yeah, it says, can you hear me now?
Now we can, yes.
Okay, it did say that my audio went out for some reason, so.
It was glitching out for a moment, but now I can hear you clearly again, so hopefully it's fixed.
Yeah,
Okay,
sounds good.
great.
Sounds good on my end too.
Okay, just let me know if it goes out again. But as I said, make sure that you are filing your requests for expungement now, and we'll take a look at those as soon as we start scheduling, which should be in the next week or so. So next slide. All right, so the courthouse is taking a number of initiatives to make certain that people are safe if they are coming to the courthouse. Our goal is to ensure not only that court participants are safe, but that our employees and staff are safe, and that's our most important. If you can imagine, if one referee were to come down with COVID and we had to quarantine for 14 days and then the other one had to quarantine for 14 days, that would really put a hit on how we process cases. And so our goal is that that will not occur. And so we've taken some significant steps to make sure that court participants and staff and employees are all safe when they come to the courthouse. So some of those things include masks are required in all government buildings. That includes in the courtroom during your court hearing if you are appearing in person. The only person that would have discretion as to whether you can take off the mask is going to be the judicial officer. So once you come into the courthouse, the security will see you, ask if you have a mask. If you don't have one on, you will be provided a mask if you don't have one, otherwise you'll be required to put one on, and it should not come off until you are given permission to take it off.
So referee, it sounds like you're still breaking up quite a bit. I'm wondering if you can maybe try like disconnecting and rejoining. You maybe still have the link.
Sure, yep, I can do that.
Sorry about that. Give it a try and we'll and there was a question that came in about getting a copy of the slides. I think we will post a copy of the slides as a PDF on our website once we get the recording up. So you'll get an email after the event is over, either later today or tomorrow with that link.
All right, is this any better?
You sound clear right now. You weren't trying to auto-tune your voice, were you?
I was not, however, that'd
Okay.
be pretty cool. That'd be a cool
Okay,
effect.
no, you sound very clear again, so hopefully that's it.
Okay, great. So masks are going to be required. The only individual who can tell you to take your mask off is going to, again, be the judicial officer in whatever courtroom you're in. We've installed plexiglass at the counters and in courtrooms to provide barriers between people. The courtrooms are limited to no more than 10 people in courtrooms, so long as it's still a 6-foot distance can be maintained. And floors, tables, seating, elevators have all been marked to indicate where you can and can't sit and or stand. So those are the steps we're taking. We're doing courtroom cleanings, door handle cleanings, and then of course, as many of you know, we have moved some of our services to online only. Go ahead with the next slide. Right, so as I mentioned earlier, one of the questions that we are frequently getting related to timelines and when you're going to get your court appearance once you start scheduling. So as I said, you know, the court doesn't have any more information than anyone else does as it relates to these executive orders or extensions of the peacetime emergency. So we literally just wait until the governor makes an announcement and issues an order for us to make a determination or plan as to what our next steps are going to be or what the timeline is going to look like. So right now, what we are anticipating is that as of August 12th, the emergency will expire. We will then begin sending out notices of hearing. We will need to schedule each one of those hearings, as I'll just talk about in a minute, related to how we're going to schedule those. And so it could be anywhere from 2 to 3 weeks to get through the backlog of cases that we currently have. And then we'll begin hearing any of the new filings that might come in on August 13th. For our initial appearance calendars in the 4th, and I believe the 2nd is doing the same, so that's Ramsey County, but we are no longer going to be doing mass calendars. So in the past, the way that we had done things is that on Monday, Wednesday, and Friday afternoons, we would have a calendar with 45 cases on that calendar. Everyone would show up at the same time. We had a number of services that were provided during that period of time, and we'd get through 45 cases. That is impossible to do to maintain social distancing. It is unsafe. It's a public health hazard. And so we are modifying our calendars and we are modifying the way that parties can appear. So the calendars for initial appearances are going to be more frequent. It's possibly going to be every day, both morning and afternoon. And we are coordinating with other metro districts so that we don't run into huge problems where attorneys or landlords may need to appear in 2 counties at the same time. So we're trying to work through some of those logistics with other jurisdictions to make sure that we hopefully aren't double booking to where we have to continually reschedule things, because that also creates a problem for us.
So what if
The calendar,
oh, I'm sorry, Referee, you're
no,
telling.
go ahead.
I thought when I appeared, you'd notice it, and then maybe you'd think, okay, a question's coming. So I figured you were waiting there. What if a Zoom call is set up like we have right now? We're on Zoom, and a tech issue comes up. And again, your voice seems to glitch out the longer you talk into a segment. So what happens with that in a court setting if Zoom just kind of fails for somebody?
Sure. So, well, my computer must be revolting. They hear it hears my voice too much. So it's like, stop talking. We understand that there might be technical difficulties. There's going to be a designated phone number to call. If there's a technical difficulty during a hearing, you'd call that number, notify them that there was a technical difficulty. Obviously, if we're on the call with you and suddenly you're gone, we realize there's a technical difficulty, and we're going to be really flexible, and it's going to be a little bit different than what a lot of people have experienced in the past in terms of there's going to be trial and error. There's going to be times when we're going to need to reschedule things that normally we maybe wouldn't have rescheduled or continued. But our goal as the court is to make sure that due process is being followed, that parties have the opportunity to be heard, and that we don't allow technology or a public health issue to interfere with those basic constitutional rights. So we understand there might be technical issues that exist, that people might try to participate in one way and suddenly realize my internet is not working if I was going to do Zoom, so I'm not at the courthouse. You know, we'll allow you to notify the court of these things. We will get you in for an appearance as soon as possible once you notify us, and we'll be flexible in that regard. But if you have to establish for us it truly was a technical issue, that it wasn't just I didn't want to.
Okay, Eric is mentioning that your audio might work better if you disengage your video. Sometimes that occurs.
Sure.
We'll give that one a shot. And are you ready for the next screen as well? I didn't mean to cut you off.
No, there's a couple of other things. So landlords and attorneys need to know, attorneys for landlords needs to know that the court is going to require a CARES Act affirmation from the landlord and the landlord's attorney at the initial appearance. What that means is that for the month of end of July, in the month of August, you're going to need to verify for us that your property does not qualify under the CARES Act, or this case does not qualify under the CARES Act, and you'll need to make an affirmation under oath on the record of that.
Is that a Hennepin County requirement, or where is that affirmation rule coming from?
That is coming from Hennepin County.
Okay.
We are going to require that. In addition to that, this is another new thing that Hennepin County is doing, so I want to make sure everybody knows about this as well. The way that we're going to start proceeding with cases when we start scheduling them again is that we will initiate what's called a 7-day adjournment. So we will be scheduling an initial appearance where the parties will appear. After that, we will adjourn for 7 days and schedule a pre-trial 7 days later. During that 7 days, we will allow the parties to access resources such as emergency assistance, mediation, or legal assistance. Those are the 3 things that we provided at our previous initial appearance calendars that are going to be difficult to provide on site and are going to be difficult for people to access within the time period of a shortened initial appearance calendar. So the 7-day adjournment is a new thing that Hennepin County is doing. We will be issuing an order outlining both the 7-day adjournment and the CARES Act affirmation so that everyone knows that we do have authority to do this. The reason that we find that we have authority to do this is because the governor signed House File 4556, which suspended all civil court filing deadlines, statutes of limitation, and time periods prescribed by state law for 60 days following the peacetime emergency. And so we're using that 60-day period to catch up on the cases that have been suspended, to manage the additional cases that we anticipate, and allow for parties to still access the resources that they otherwise would have had access to.
Okay, referee, Houghtaling, the 7-day rule that you're just talking about sounds similar to me to when a tenant used to ask for 7 days to come up with the money to pay rent, and the referee or the judge might grant them that time. That's different than what you're talking about right now?
That is different than what we're talking about right now, as it's not going to be a redemption order. So it's not, you have to pay by that 7th day. It's that you need to go and access resources. Then we're scheduling a second hearing on that 7th day. And it might be a Zoom hearing, it might be a telephone hearing. And it's essentially a check-in to say, okay, landlord and tenant, did you go to mediation or did you talk to one another during the 7-day period? Were you able to access some sort of emergency assistance funds or housing funds to determine if that would help you resolve your case? Did you access any legal advice that you might have wanted to access? We'll be checking in then. If all of those things took place and there's still no resolution, we'll then set it on for a trial, or we'll set it on for the 7-day redemption period if there's no dispute as to the amount of rent owed.
What if the tenant doesn't appear for the initial hearing? Would the 7-day adjournment happen then, or would the case simply be found in favor of the landlord at that point?
It will be found in favor of the landlord.
So the tenant has to appear somehow to get that 7-day period?
Correct.
Okay.
Or file a Rule 60 if there's some reason that they couldn't appear, you know, that their non-appearance was due to circumstances beyond their control.
Okay.
Or, I mean, if they don't want the 7-day adjournment, we're not going to force people to do it. But we are going to use our discretion to provide that 7-day adjournment. So if a tenant says, I don't want that, like I don't need that, then we're not going to force a second hearing on people. However, we want the opportunity to explain what's available for people to access resources meaningfully, and for us to be able to manage the cases a little more effectively and not as rushed as we sometimes are. You can go to the next slide. All right, so some of our predictions. For people who don't know, in Hennepin County housing, we tend to have 450 to 550 new residential eviction filings every single month. So if we average each month and say there's 500 new residential eviction filings per month, that's the possibility of 2,000 unfiled residential eviction actions just waiting for the suspension to be lifted, and could be filed in the first few days of the lifting of the peacetime emergency. So not only is the court anticipating we could potentially have 2,000, and that's on the low end, in all honesty, that 2,000 number, but we have to process all those. So while you might file electronically, there's a person who processes all that. There's actually 6 people who do it, but all of that takes time, and so you have to keep that in mind as you're moving forward. And anticipating that after the CARES Act protections, that's probably in August when we think we'll see the larger influx after that 30-day notice, and the Minnesota moratorium expires, which is August 12th. We could see numbers rivaling or exceeding 2008 and 2009. Is my speaker working still or not?
It is glitching out a little bit. Like I said, whenever there's a pause in your speaking, then it seems to fix itself. But I had a couple questions, if you don't mind, about what you put up here. First of all, the 2,000, how we've been doing the math is we started it for April, right? Because the moratoriums were granted or declared in mid-March. So most of March's rent was paid. But so we have April, May, June, and July. And now the new order extends into August. So I think that number would be 2,500 unless somebody ends the peacetime emergency before it's supposed to naturally end at this point. Am I right about that?
I would say 2,500 is probably accurate.
Okay.
I lowered the number a little bit because I think where we really have a big question mark is at the beginning of August in terms of rent payments, when all of the unemployment benefits have then come to an end. You know, in July, it's something like, okay, well, in August, I used to have, you know, $2,400 more a month, and now I don't have any of that. So
sure.
Honestly, I think it's going to be something that we've never seen before.
Right. The second part of that, second bullet point you have there is the first few days is when, because this is something I've talked about in prior weeks, and I actually look at the list of people who attend, and I know you've watched some of these, and I'm guessing you've heard us talk about there isn't much of a reason why a landlord would wait to file an eviction, is my view. If they're going to file, and now, let's say it's in August and the 7-day rule is in place still somehow, there's still going to be some day where landlords can go file. And some landlords aren't going to file. They're going to try to work out a deal with the tenants. But the ones that are going to file, I don't see why they'd wait at that point. So I'm guessing you're right that it's going to be in the first day or 2 or 3 because landlords are going to want to get in line as soon as it's legal to do so.
That is correct. But the reason that I wanted to emphasize how long this is potentially going to take people to get into court, to get a hearing, is because I want to encourage people to talk to one another before filing. Because so often in non-payment of rent cases, landlords file, they come to court, they reach a settlement agreement where there's a payment plan. And if you had talked a week before or 2 weeks before or before you filed, you could have come up with that payment plan in advance. And there's no, and I get that you get the immediate writ if they miss a payment, and that's part of the carrot on that settlement agreement. But I think at least now, when we're going to have such huge numbers potentially coming before us, and there's so many concerns about what's going to happen in the fall. What if there's a resurgence? What if we close down again? It's really worth it to have people talking to each other and accessing resources as much as they can, because I think that the more you can do outside of court, the better off both parties are going to be.
Right. You had mentioned earlier that you'd had calendars, the Monday, Wednesday, and Friday calendars of 45 cases. You used that number. I just did some quick math, jumping our number up to 2,500. That's 55 normal pre-COVID-19, shove everybody into the courtroom calendars. That's how many calendars you're talking about. That's how many mornings or afternoons you'd need. So it's going to be a huge undertaking for especially Hennepin County's eviction court with those kind of numbers that you're looking at.
That is correct. And there's only 2 of us that do it. So, this is what, the judges and everybody in admin is saying, if we could clone referee Houghtaling and referee Cedillos and we could have as many hearings going on as possible at any given time, then sure, we could get through, all of the cases in a day. However, it's just 2 of us. We have other court obligations, and if cases are going to trial, we have to schedule those trials as well. And so it's just a matter of logistics and time. And we're trying to work through that as best we can. We do understand that there are cases that are urgent for people, and we're going to, to work through them as quickly as possible.
Have you asked the governor for an executive order to clone you?
I haven't. I don't know. I think it'd have mixed results. I think some people would like that. Some people would be like, please don't.
Fair enough.
So, yeah. All right, we can go to the next slide. All right, so one of the things that I wanted to make sure everyone on this webinar had access to were all of the resources that are currently available. Just yesterday, I received an email from the city of Minneapolis, not a personal email, but like a large mass email that said the Hennepin County Emergency Rental Assistance Program still has a significant amount of the $15 million in CARES Act funding that's available. The city of Minneapolis was encouraging landlords to contact the Hennepin County Emergency Rental Assistance Program if their tenants are behind. My understanding with working with, Hennepin County Emergency Assistance and the other financial groups that are out there for tenants is that they're out there for tenants, but also for landlords, because their goal is to make sure that people are being housed, and they understand that landlords need to get paid. And so they're willing to work with both landlords and tenants to make that happen in non-payment cases. In addition to that, you can access any of these resources before you file an eviction action, before you come to court. The Tenant Resource Center is a great place to start if you need access to other resources, but they'll probably direct you to the resources on this slide. The Conflict Resolution Center and Community Mediation and Restorative Services are two mediation services that provide mediation at our initial appearances, and the court actually has a contract with them. So if you contact them outside of the court hearing, they should provide free services to you if you have an eviction action pending. So contact them if you'd like to have mediation occurring between now and whenever you get a hearing, or if you do resolve a case, so you settle with your tenants, you settle with your landlord, let the court know so that we can take that case off of our calendar. So file a dismissal or file your settlement agreement if that's what you choose to do. Minnesota Assistance Council for Veterans, so MACV, is another place for some funding and some housing assistance. For legal assistance, Legal Aid and the Disability Law Center are working together with Volunteer Lawyers Network. If you call there, they'll connect you with a lawyer. Homeline, of course, is a wonderful resource. And new as of yesterday, the governor has announced that there's going to be $100 million for a program to provide housing assistance in Minnesota. I'm not sure how they're distributing that or who's going to be in charge of distributing it. I don't think they know quite yet, but keep that in mind, because we anticipate that a majority of the cases that we're going to hear are going to be cases related to non-payment of rent. And so if you can access money in advance, that's going to be the key to either avoiding an eviction being filed or finding a resolution once you are in court. So
Okay.
now we can do questions.
Yeah, this is my favorite part of every week right now is the question and answer session, because you get some things that you hadn't anticipated. And I try to go through it quickly. We have about 45 minutes left on our session, and I'm guessing we won't get through all the questions. We've had several submitted in advance today. Other people have been submitting them through the chat box or the Q&A box. Also in the chat box, and you should all have that open, those of you that are watching, Eric has been posting links to things that have been brought up throughout. And so I would encourage you to make sure you have your chat box open. But we are going to start, Referee Houghtaling, with some of the questions that were submitted in advance. And some of them have already been answered, so I might be skipping ones. I know you have them in an order probably that I sent to you earlier. But I'll start with the first one, which is from Ms. Green. Will people be able to get the eviction expunged off their record since this was not their fault? So I'm going to modify that question because I'm not exactly sure what she's asking about. And I'll start it with this. If a tenant had one of those wrong, that was my bad description of it earlier, an eviction filed during the eviction moratorium that is probably a misdemeanor, will that be expunged automatically? You said it's being kept confidential right now, but later will it be expunged?
Yes, we will automatically dismiss and expunge.
So the tenant would not have to file a motion to expunge those cases?
Correct.
Okay. And I guess the second version of that question would be, let's say the eviction moratorium lifts, a tenant's not able to pay their rent because they lost their job because COVID-19. Will that eviction be expunged? I think is what she might be asking. I'm not sure.
So that would not qualify for the immediate expungement category unless there were some other procedural issue. Most of the cases that we hear pre-pandemic or post-pandemic related to non-payment, unfortunately, do relate to loss of a job, a sick child, an unexpected death in the family, an unexpected expense that came up, and those things were paid before rent was paid. And while that's extremely difficult to hear, that doesn't, there's no law that says that an unforeseen circumstance excludes you from an eviction action. So that would not be subject to an automatic expungement.
Okay. Next question comes from Norma, and this is one of the questions that I'd come up with on my own, which I've always kind of wondered about, which is how often do judges from around the state pick your brain or the housing court referee in Ramsey County, because the volume that you guys deal with on housing court cases is so massive, versus a judge in Beltrami County, where they hear some evictions, but not a lot of them. Have you been getting questions from around the state saying, how am I going to do an eviction when they come up? Are you seen as that sort of the state expert at this point for them to consult?
So I do get questions from judges across the state. When a judge is appointed or a referee is appointed, we go to new judge school with each other.
I love that image.
Yeah. So we do this thing, it's a week long, but you get to know judges from other jurisdictions at that time. So oftentimes I'll get messages from other judges that were in new judge school with me because they know me. We also give presentations at statewide judge retreats and judge learning opportunities. So I've given presentations at those events. But yeah, we do get contacted in Hennepin and in Ramsey. The difference is that we have housing court in the fourth and the second. And so we have the rules of housing court, and the outstate jurisdictions or venues do not. So that's a little bit different. When you're thinking about Beltrami County, they don't have the housing court rules. They just do the rules of civil procedure. We have the housing court rules. But we make that distinction when we're talking to them. We also have a judicial desk book for housing that is available in PDF that judges have access to.
Sure. Okay. Next question is from Joshua. Can we terminate a lease early without penalty if the apartment building is not enforcing mask use? I'm not sure if Joshua is a landlord or a tenant. I'm guessing a tenant from that question. So they want to, I guess, break their lease early without a penalty if the landlord is not enforcing the mask use.
That is a good question. And I think that it may be one that comes up before us in the courtroom. So I probably can't answer it without having argument from both sides and giving any legal advice, but maybe Mike or Eric, you might have.
Sure, and this is how we'll do this today. I'm sending every question to you first. And if it's one that, I mean, honestly, a referee in housing court doesn't hear every type of landlord-tenant dispute. I mean, mostly it's evictions, some rent escrows, expungements, lockouts, and ETRAs. That's pretty much the list, right?
That is correct.
Yeah. So something like this, kind of a lease analysis question, isn't something you do on a daily basis. For a question like that, short answer for Josh is it's complicated, maybe. And this is an answer I'd give a lot, and I do every week. You really should talk to somebody at our free tenant hotline or email an attorney service, and Eric will put that in the chat box, how to contact those folks, or on the big screen, because we'll need some more details to give you the right answer instead of just a guess based on the info you gave us there. All right, Linda's got an interesting question. She's asking you to use that crystal ball, and she's saying, or asking, what innovations during COVID might the courts have a tendency to keep in future when back to normal, like Zoom, for instance, expungements? Could those be done by Zoom or by phone all the time instead of making everybody trek down to the courthouse?
Great question. And we are considering this as we move forward because we don't want to put a whole lot of work into something that's only going to last for 4 or 5 months. We'd like it to be something that's more permanent. For expungements, I think so long as there's not a huge challenge or a Court of Appeals decision that tells us otherwise, we'll continue to do these administrative reviews. I foresee that happening so that we don't require people to come down to the courthouse for expungements. As it relates to access via Zoom, I think that we will probably allow that to continue as well. So as long as there's a public health concern, these are going to continue. So just because a peacetime emergency is lifted does not mean that we're going to stop these particular innovations. Our goal is to make sure people are safe. So just because the peacetime emergency is lifted doesn't mean that there's not still a public health crisis. And so long as there's a public health crisis, we'll continue this way. And we'll just have to see how we can handle the volume that we have in the way that we're anticipating handling them to see whether we can continue doing it that way.
Okay. I'm going to go down the page. A couple of these questions I'm guessing are going to be for us, and so we'll get to them if we have time, but I want to get the ones that really are directed towards you today. From Deborah, why don't the housing courts start addressing the cases now that were filed before the moratorium went into effect?
Sure. So the reason that we're not doing that is twofold. One, we had our own order from the Chief Justice of the Supreme Court that said we needed to limit courthouse access. So that was the first thing. The second thing is that the sheriff can't execute any writs, and the governor's order specifically says no writs. So what's the purpose of us having a hearing if we can't issue a writ? I mean, it's a simplistic way to think about what we do in housing, but that's really what it is. The landlord wants the writ. There's nothing that says that you can't have conversations with one another and come to a settlement agreement during this interim and file that settlement agreement as you would if you came to court. But if it's a writ you're seeking, we are not issuing writs because the governor's order prohibits that.
Fair enough. Okay. Lisa's asking about homeless people have missed courts. Can organizations working with them help reduce warrants and connect all involved? So trying to expand this into your realm. How do we work, or how do any social service type agencies work to make sure that tenants are able to appear in court? And by appear, it's either physically or by phone or by Zoom. What would you recommend to that group of people, the social work world, to try to help make sure that their clients are able to get to court and attend and participate in these hearings meaningfully?
Sure. So the first thing is the information as to how to participate meaningfully is going to be on the summons that the participants receive. So the summons is going to include how to access the courthouse, how to access Zoom, or how to access telephone, which is through Zoom. So essentially making the phone call through Zoom. So all of that information will be on the summons. The summons is required to be served on the tenants by law. If the summons isn't served on the tenants, then the court doesn't have personal jurisdiction over the tenant. If the tenant misses a hearing because of homelessness, transportation, or some other issue beyond the tenant's control, and we've issued an order for default, you can always file a Rule 6002 motion and explain why they didn't appear, why the non-appearance was not their fault, and explain why the court should reopen it and it wouldn't be prejudicial to the landlord. If you explain those things, I would say 95% of the time, reopen and schedule it for another initial appearance. So those are the ways that you can advocate. As it relates to the technology to access the Zoom hearings or the telephone hearings, I know the Tenant Resource Center is working on getting a room with a computer available so that parties can participate that way. If the parties are being represented by Legal Aid or Volunteer Lawyers Network, they are providing the remote access for people. And then the court is also working on this is a big question mark, so do not quote me on this, but this is
recorded, just so you know, we're recording.
Yeah, so we're working on some remote technology available, whether that be, on the second floor, on the Skyway level, a room where somebody could access some technology if they couldn't make it up to the courtroom or they didn't want to be in the courtroom with other people. So.
And Eric just posted the link to the Tenant Resource Center in the chat box that you just mentioned. So there's how you find them. Okay, next up is from, you were done with that answer, correct, referee?
Yes.
Houghtaling? Okay. Janice asks, actually this was a lengthy question and we advised that she contacted our hotline earlier, but I'll give you kind of a couple key points that I'm not sure you can comment on, but you can give it a shot if you like. Can the landlord force us to get tested and demand results? We're not sick and do not have the virus. We are Black and she is white. And again, she sent us a long question, and discrimination seems to be a big part of what her question is. But the basic question I think for you is, can the landlord force us to get tested and demand results?
So my answer would be, if there's nothing in the lease, we're very contract based. So, I mean, if the lease says, if there's a public health concern and we need you to participate in any public health testing, I guess then the landlord could technically make you do that, or you would breach the lease if you didn't. But I'm going to guess that no lease in Minnesota contains anything along those lines, as we haven't dealt with a pandemic since I think the early 1900s. So,
well, I guess I could see a lease that was started after the pandemic that a landlord might have put a clause in like that. I haven't read one yet, but it's not impossible to consider. But let me assume that there was one for a second, that the landlord had you must get tested when I demand you get tested, or else I can file an eviction against you. Would that fall under the endangering the safety of others and allow the landlord to file an eviction under that rule? Do you think it would fit under that umbrella?
So I think the landlord, I always say people can make whatever arguments they want to make. I
Sure.
think the landlord could make that argument. The parties could come to court. The tenant could argue why it's not. And the court would have to, we haven't had this question, but the court would have to consider, I think, a lot more than just whether the tenant refusing the testing is a violation of the lease or seriously endangers other people. We'd also have to consider whether a landlord even has the right to require that, if one individual has the right to contractually require that of another individual when it involves an issue related to health.
Sure. A lot of complicated cross sections of the law that come into play there. No question.
Yeah, I think that it in my mind, my initial reaction is it sort of maybe raises some constitutional questions and liberty questions, but
fortunately you haven't had to deal with it yet. So there we go.
And hopefully I won't. So.
Right. Eric, this might be a question for you. Karen asked, were any tenant assistant rent funds found specifically to Moorhead or Clay County?
I'm not 100% sure on that, specific to that city and county, but the referee did reference that the governor passed along $100 million in federal CARES Act money to the Minnesota Housing Finance Agency. That was announced in a press conference yesterday. And my understanding of that is there's a process where they go through an RFP process, and agencies, governments, et cetera, that are interested in administering that rental assistance fund, or a portion of it, will be applying over the next week. And then they'll make announcements in late July or early August about what organizations receive that. And then sometime in mid-August, tenants will be able to start seeking rental assistance that's coming from that pot of money. And there'll be more information in early to mid-August about exactly what agencies, organizations, government entities like counties or cities or community action programs, whatever agencies are going to be administering that program.
And again, that's statewide. It's not specific to the metro.
The RFP is statewide, but it may end up going to a portion, they'll portion it out, the 100 million. And so some might go to, is Moorhead in Clay County, is that right?
Right, yeah.
Yeah, so it might go to Clay County or might go to a nonprofit community action agency or something like that. There'll be a lot more information about where it's going and how you can access it in mid-August, I believe. And the funding pot, there's still some questions about how it's going to work, but it is supposed to be available for rent arrears from March 1st through December of this year.
Okay. Next up, we have a question from Zach. Okay, what would be considered a serious endangerment of other residents? So Zach is referring to the old language of the exception that the governor had. The new language, of course, is others on the premises. So that would include caretakers, landlords, delivery people. But can you give some examples, Referee Houghtaling, of cases where a landlord has successfully argued, and not not the names of the parties, but just the specific type of serious endangerment that was enough to win an eviction case since COVID-19 began?
Sure. So some of them have been guns being shot off in the property. So guns going through floors or walls, drugs at the property, in the hallway, in the hallway, needles being left in the hallway by specific tenants when there's proof that it is that tenant who is doing that. Tenants who have, a lot of them involve physical assault. And so where there's been a physical altercation where tenants have attempted to break into someone else's unit, where a tenant is doing something in their unit that then affects another unit. So say, for example, and this isn't something that's happened now, but this would probably qualify. If a tenant ran their bathtub and plugged it and refused to unplug it and continued to run the water so that the water went into the unit below them, that might be considered, if the tenant was doing that intentionally, right? That could be considered seriously endangering. Allowing unauthorized occupants who have violent behaviors towards other people. A lot of the serious endangerment, in all honesty, involves physical violence, drugs, significant threats that the court finds probable that the threats could be carried out, right? It's not just name calling, but something greater than name calling. You know, they're holding a weapon and they're threatening, or they're holding a knife, they're holding a rock, you name it. Those are the sorts of things we see, but those are the types of serious endangerment cases that we've heard that have been successful.
Okay, I'm going to jump to some of the questions that we have been getting today live. Most of the other pre-submitted ones are ones that will probably move to next week because I just don't think that they're really targeted towards the stuff that you work on a daily basis. So we're going to take some from the chat box first, and then we'll go Q&A. So from Joey, we have, what is your opinion about the cases being filed now that don't meet an exception in the executive orders? So the one you mentioned that there were 5 filed this week that were just non-payment cases. So does the court have an opinion about that they'll be dismissed or that they'll be labeled wrongfully filed? We're getting a couple questions asking about this. So either they came in before we clarified it or else they just want some extra clarification. So if you could restate the court's position on the wrongfully filed cases during the peacetime emergency.
Sure, so we'll dismiss them, but they will be granted a hearing first. We've gone back and forth about how to do this, but we feel that the tenant should have notice that it was filed, because at this point the tenant doesn't know.
How will they be notified if they're not served by the landlord?
They'll have to be served. That's what I'm saying. We'll set a hearing.
Okay.
They'll have to be served.
Yep.
And then they'll come to the, whether the tenant comes to the hearing or not, we'll inform the landlord, you filed this incorrectly, it's getting dismissed and expunged.
What incentive would the landlord have to even come to court? It seems like one of those tax schemes where you've won the lottery and the IRS is really just waiting there to scoop you up when you show up.
What incentive would they have to come
With
to court?
the landlord, if the case is going to be dismissed no matter what, when they show up, if it was filed wrongly?
They don't.
Right.
They don't
Okay.
have to. I mean, they don't have to. If a landlord doesn't show up anytime, we dismiss.
Sure.
And expunge.
And you mentioned earlier that those cases are going to be expunged without motion by the defendant being necessary.
Correct.
Okay. Okay.
So it's just to be clear, it's in Hennepin County, it'll be automatic, basically automatic. Tenant gets notified and then there'll be a hearing. Tenant doesn't have to show necessarily, and then it'll be dismissed and expunged.
If it was filed in violation of the executive order.
Right.
Okay.
Like a non-payment case filed this week. That's the example we're talking about. Right.
Correct.
Okay.
Yeah. So, and we should just clarify again that this is Hennepin County. We're talking about 4th Judicial District, and other counties may do something similar, but there's no assurance of that, right?
Correct.
Okay.
Correct. And you know, we've gone back and forth about how to handle these. And part of what causes us to schedule the hearing is that the party should have noticed that a case existed to begin with. And secondly, there's the criminal provision within the executive orders. And at this point, there's no way that the AG would even know that these cases were filed because we've designated them confidential.
So will that information be shared with the AG's office, or would it transform straight from confidential to expunged? And then, I guess the landlord's name is still there, right?
So the way that it will work is that, at least this is how my understanding of how it will work, that once the peacetime emergency is lifted and we begin scheduling, the minute we begin scheduling the hearings, the confidential notation is removed.
Okay.
So there'll be the period of time from when we issue the summons until the date of the initial appearance, where the file will become public.
Mm-hmm.
And then once the hearing takes place, we'll issue an order to dismiss and expunge. And we sort of hold them, we then make them confidential again and hold them for about 7 to 14 days before we actually delete, you know, hit the hard delete button. But if we've just determined that that's the best way to handle it, to make sure that everybody has all of the information necessary publicly.
So the downside to that is that the tenant is going to have an eviction on their record the day after the peacetime emergency is lifted for some amount of time.
They will have it on their record from the day that the summons is issued until the initial appearance.
Okay. Okay. Got it. Okay. All right.
One quick question. At that point, it'll be public, and so the Attorney General's office might learn about all of those cases.
Correct.
Yeah.
Yep.
Okay.
Okay.
The court is not a reporting authority. So, you know, we're not the police. Is what I always tell people. We're not the police. We're not a reporting authority. And so but we also can't keep things secret. So that's sort of why we're proceeding the way that we are.
Okay. Next question from Julia. I know of a pro se individual. Pro se means not represented by an attorney, who filed a rent escrow since the pandemic, and it is confidential. Why would that get a confidential designation?
In Hennepin County?
It doesn't say, so I can't be sure here. I guess a fair question would be, if a rent escrow is filed right now, is it labeled confidential in Hennepin County?
Once we scheduled for a hearing, I do not believe so. When we initially stopped hearing all of the cases, when we weren't holding any live hearings, so like for the month of, you know, for March, for April, for a good chunk of May, we just made all cases confidential. But now that they're being scheduled, it should no longer be confidential, and it should have been scheduled.
Okay. All
so
right.
At least that's how it is in Hennepin County. So if it's in Hennepin, that's what should be happening. So I can't say much more about that.
Okay. Question from Kim. We're still primarily planning on using Zoom for the typical preliminary hearing when possible, correct?
That would be the ideal situation. If people have access to that technology, that they use that technology, yes.
Fair enough. Okay, new question from Joey. At what point will a default order be issued if a tenant isn't able to enter the meeting? So I guess she's implying that it's going to be a Zoom or a phone call. How much time lag will you give them? Do they get a 10-minute grace period, or how does it work?
So I have been doing 15 minutes. It's very similar to the in-persons. I usually give people 15 minutes, you know, to be late, essentially. If it's a technology issue, I would hope that they would contact us immediately. Like just call the court and let us know I'm having a technology issue. Or all else fails, you know, show up to the courthouse. So.
Okay, I think I have a question from the Q&A box that was based on the safety endangering others. What about two tenants verbally and physically fighting each other? Do you think that would amount to endangering safety of others?
So the answer to that is it depends. So
There's
are
a
the
judge answer
tenants,
right there.
right?
Yeah.
If the tenants are members of the same household, does that qualify as domestic abuse?
Mhm.
And then does that qualify? Then we have to determine whether they're protected by VAWA, so the Violence Against Women's Act, or if they're protected by 504B.171. There's an exception in there related to domestic violence. So if it's two tenants fighting and they live in the same unit, we have to determine whether it's a domestic violence issue, and then it becomes more complicated at that point to figure out what's going on with the violent situation. If it's two tenants who are fighting each other and they're not in the same residence, that would probably qualify as an exception. That would get you into court. Then it's up to the landlord, and they must have proved by preponderance of the evidence that it's a violation of 504B.171 or a violation of the lease at that point. So the serious endangerment sort of gets you in the door to us right now, and then you still have to prove your case. Just because we grant you a hearing doesn't mean that you won.
Are people asking for the serious endangerment and then saying, and also they haven't paid rent? Are they putting that in the eviction complaints?
Some are, yes.
And what happens with that part? You just say, we're not talking non-payment of rent, we're only talking about the other portion?
I say we're not talking non-payment of rent. We only talk about the serious endangerment, that I'm not allowed to hear non-payment of rent cases. I sometimes question whether there's truly serious endangerment if there's a rent, if the rent line is filled out. So I sort of say, are you really here because you think that the tenant is dangerous, or you're here because you're mad that you didn't get your rent and that the governor said you couldn't come here because you didn't get your rent? And I have had some settlement agreements that are reached at the hearing where there is a payment plan in the settlement agreement, and I say I will not allow a writ to issue as it relates to this payment plan. However, that's fine if you want to have an agreement related to that for the purposes of an automatic administrative expungement, which is something that Hennepin County does and permits in settlement agreements. So I sort of see it as a settlement as a bargain for exchange between the parties, but the court does have control over the writs. And so I say no writ if they miss a payment. But if there are other terms related to a writ issuing, a priority writ issuing, then I'll allow it for those other terms.
Okay, next question, a little lengthier. A tenant had a fire in their apartment. I, the landlord, put the fire out and, oh, sorry, just lost my place there, with a fire extinguisher. Now the insurance company wants to do a small renovation, but tenant will not allow anyone in the apartment. The insurance company insists the work must be done because of toxins produced by fire extinguisher. What can I do? And I'm gonna make this a question I think eligible for you. What if the landlord were to try to file an eviction for that purpose? And you can answer it COVID-19, non-COVID-19 era, however you want to answer.
Sure. So if they want to file an eviction now, they'd have to establish that there truly are dangerous situations in the property for the tenant, right? So the governor's order also says, endangers the landlord's property. There's the property provision in there. So tenants who are, tearing down doors or walls or removing copper or anything along those lines would also qualify as a serious endangerment issue. So the question would be, is this truly an issue? These alleged fumes, are they truly an issue, or is this the insurance company's way of saying, do something now or we're not going to pay you? I don't know. People have different motivations for different things, but you could probably get a hearing before us as it relates to the repair itself. You know, if I were the landlord, I would just document that the tenant's refusing access. So then the tenant couldn't bring a rent escrow saying landlord didn't fix it when the landlord was trying to. But if it's still allowing for all of the provision of any services that would have otherwise been provided as part of the unit, then if the tenant wants to live in that condition, then I don't know how much the landlord can do right now.
Sure, sure. We have about 10 minutes left, and we're going to try to get through whatever questions we can, but here we go. Tenant refuses to wear masks in common areas of apartment building. Can I enforce the mask rule? First of all, I'm not entirely sure. I think there's some cities now where masks are required in Minnesota. I'm not sure that there's no statewide rule that I know of, but we've been locked into a meeting for 90 minutes, so maybe a new rule came out. I don't know. But what do you think? Could a landlord, again, I think we've talked about this, file an eviction for endangering the safety of others for not wearing a mask in the common area at this point?
I think you could give it a shot,
Mm-hmm.
and then the court would review it. You know, I'm just one of 2 referees that review these. I'm
Right.
one of a number of judicial officers throughout the state of Minnesota who's reviewing these sorts of things. And we all see things differently. I mean, the other referee and I sometimes differ on what we see as serious endangerment. And that's part of judicial discretion in these particular cases. But, you know, if you truly believe that it's seriously endangering other people, then you can bring it to court. If you're trying to find reasons to get a tenant out because they're not paying their rent, I think that that's not proper.
Sure. Okay, I had an old eviction filing, which was readily resolved in 2017. How do I find out if I still need an expungement? Is it public record that the filing is still on my record?
If you have not been granted an expungement, then it is public record. Evictions become public the minute that they're filed, regardless of the outcome. So if you settle it, if it's dismissed in your favor, if it's dismissed, or if it's judgment is entered in favor of the landlord, regardless of the outcome, the eviction still exists on your record as an eviction filing until your record has been expunged. And if you haven't requested an expungement in 2017, there were no administrative expungements as far as I know. So I'm going to guess that it's still there.
Okay.
But you can always use the public access and use your name and see what's happening on public access.
All right, the next 3 questions are all kind of court logistics questions, and I'm guessing you'll answer them quickly. If someone comes into the government center without a mask, will one be provided for them?
Yes.
Okay. Has there been discussion about hiring more court staff and referees to ease the backlog?
We are on a hiring freeze. So my clerk is on maternity leave and I almost didn't get a clerk. So
wow, this is not the time to not have a clerk.
Correct. I have we have a replacement borrowed from another judge right now, but no, there will be no additional hiring, at least at this point.
How will the government center handle social distancing on the elevators?
Sure. So the elevators are restricted to 2 unrelated parties on the elevators at a time. There's little circles in the elevators showing you where you can stand. The court tower is designated only for court visitors, and all employees use the A tower to access our chambers and courtrooms.
Okay. If a tenant had an eviction filed in March or April that is part of the backlog and they've since vacated the unit, would that eviction be appropriate for an immediate dismissal and expungement once the court hears the case? I'm not sure what they mean about an April case, because that would have had to be a 171 or serious endangerment case, but let's just assume that it was one that was filed back in March. If the tenant vacates, would it be an immediate dismissal and expungement once the court hears a case?
If the tenant's not there anymore, I would encourage the landlord to file a request for dismissal and expungement in advance of us having to schedule a hearing. It's what the court does is award possession. And I think I probably sound like a broken record sometimes when I tell people this, but that is what we do. So when you come to court, to eviction court or to housing court, you're asking the court to award the landlord possession or award the tenant possession. So who gets to be there? If the person isn't there anymore and they voluntarily vacated, there's no need for me to issue an order saying that the landlord gets it back. If you have the keys and you've had possession for 3 months, there's no reason for there to be an eviction action to begin with. So you might as well dismiss and request, whether you request expungement, that's up to the landlord, but you could dismiss the case, take one of those 315 off of our list of backlog, and then save yourself a day in court.
So I'm not sure that you'll know the answer to this one, and I'm not sure that I do either, but you probably are pretty familiar with all these resources. Can tenants get help from VLN, the Volunteer Lawyers Network, remotely? I've brought clients to the VLN open hours at the government center to get help with the paperwork and filing the motion, for example.
Yes, everything is being offered remotely at Legal Aid and VLN.
Okay.
So the phone number I provided will connect you with someone at VLN or Legal Aid, and then they will provide you with information as to how to do a Zoom call or a phone call with them.
Great.
Yep, so everything can happen remotely right now. All of the services that we provided previously.
Okay. Here's a question that I think is following up on a question from before. Are expungements really a need, considering the new renters protection for evictions 3 years and older?
It's up to the party whether you think it's a need or not.
Right.
The way that it works for eviction actions, as I said, is the minute that they're filed, they become part of the public record. We still have cases on our books from 2010, 2011 eviction actions. And so if a tenant screening agency pulls records from Hennepin County, they're going to see that you had an eviction, whether it was last week or not last week, I suppose, but whether it was in January or February this year, or whether it was 5 years ago. If you have not had it expunged, it will still show up.
And just to be clear on that question, the 3-year rule that's being referred to there is not a countywide or statewide rule. We're talking about Minneapolis and next year, St. Paul. So it would not necessarily get an expungement if you lived in Bloomington, for instance, or some other part of Hennepin County. All right, last question I'm going to ask from our list. I have a family who has experienced numerous random gunshots, which broke a couple of windows. Is it the landlord's responsibility to repair? I think they're implying that the tenant didn't fire the gunshots, that somebody else did. Who should have to fix those?
So I would say either can fix. The question is who's ultimately going to pay for it.
Mm-hmm.
And that's not going to be a housing court question. That's going to be a conciliation court question, where the landlord, maybe if they fix it, might say that it was the tenant and try to charge them for it. Or if the landlord refuses and it's affecting your habitability, you could bring a rent escrow action once you demand the landlord fixes it.
Okay, we only have a couple minutes left, and I wanted to ask you kind of one big picture question. Clearly, the world is so different than it was 5 months ago, but just in that small arena, the Hennepin County Housing Court, based on COVID-19, what is your biggest concern in the next 5-6 months? Or can you just sort of summarize what you're trying to make sure you pre-solve before the doors open up again fully?
So that is a really big question, because I think there's a lot of things that we're trying to pre-solve. So first and foremost, the courts are responsible for following the court rules, following statutes and deadlines, and making sure that the parties are doing the same thing. So we have to make sure that we're following all of the requirements. And whenever we're planning for moving forward, what do those requirements look like for us so that we're not violating anything as we move forward? The second thing that we're looking at is how can we keep everyone safe during this period of time? So how can we reduce exposure as much as possible so that we aren't creating a larger outbreak situation? And then third, how do we make sure that all parties are heard and have an opportunity to access resources effectively, and don't, I know that people already feel like they're pushed through housing court. I hear that complaint all the time. It's not lost on us. But how do we make sure that we aren't making things worse by changing how we do things, and that we're ensuring that people have proper notice, that they're able to appear, that they feel safe when they appear before us, and that they feel heard once they're there, whether they like the outcome or not, that they at least feel heard. So that's sort of the broad picture of what we look at when we're doing a variety of planning, and we look at how does this affect landlords, how does this affect tenants, how does this affect advocates, how does this affect service providers. We have a lot of stakeholders that are at play when we're looking at either changing something or modifying something, and we want to make sure that everybody's voice is heard, and that we are initiating changes that are going to be useful to people and not just a method of churning through things.
And the last thing that I'll mention is we get asked this a lot. What is the governor going to do? Tell us what the governor is going to do. You must know. You guys have people on the inside. And I mentioned that story at the beginning of today's session, that you and I were in contact last night, and you hadn't even heard about the new governor's rules. We hadn't until they were announced either. We don't have some pipeline to the governor's office, and it sounds like neither do you. You're finding this stuff out when the rest of the world does. Is that fair to say?
That is 100% fair to say. And I wish, if I had one wish, it would be that we did have some sort of pipeline to the governor when these things are happening, because we do this every single day. And I've been doing this every single day for the last 2 years. So I think I have a pretty good idea of what tends to work, what doesn't work, and what the potential is moving forward for catastrophe, right? And so I would love to have the governor or lieutenant governor's ear to just sort of walk through some of this, particularly for Hennepin County, who we do have the highest volume of housing cases in the entire state. And in all honesty, I think it's going to come down to a money problem. And so I'm glad that we see money coming forward. I just hope that it reaches the people and the resources that are necessary. Landlords, I need their money so that they can pay taxes. I just got that question the other day, like, are you going to push out the tax deadline for landlords? I'm like, I don't push out any deadlines. But you know, all of those things, it's an economic circle that exists for landlords and tenants that's really complicated. So yeah, I wish I had a crystal ball. I wish we got, like, you know, even an hour heads up, hey, this order's coming down. But no, I got it when I got your email this morning. I said, oh, okay.
Well, I can't thank you enough for coming and spending 90 minutes with us today. It's been very informative. As you know, we record these sessions. People are going to be watching this for a while. And if I know at some point you're going to be incredibly busy, but my hope is that we might be able to have you back on maybe right before the doors open up if we get more heads up. The governor's giving us an advance warning on this one. It's August 4th when it goes into place. So if we have some sort of 1 month warning, for instance, when the eviction moratorium will fully be lifted, we might hope to have you on once again to talk to a broad audience.
I'm happy to come back anytime. One of my big things is the more you know, the better, and the courts should not be cloaked in some sort of mystery. So, you know, I'm kind of an educator at heart, and if I can help people and demystify the process and try to make things more accessible and less scary, I will do that. I know how scared I was as a new lawyer, even appearing in court. And so as a self-represented litigant, I know that it's 10 times scarier. And I want to make sure that people know that we are people too, and we're thinking about all of the issues that are involved and the consequences that exist. So anytime you want me back, I will come, with the caveat that I will actually be on leave probably starting in October because I'm expecting my first child. So
Oh, congratulations.
thank you. Yes, nobody knows this because you only see me from shoulders up these days. So
Well, somebody else must know. You didn't just announce it to the world on our webinar.
I did not just
Okay.
announce it to the world in your webinar.
It'd be such an odd thing. I've been waiting to be asked on your show. Yeah.
Yeah. No, there are plenty of other people who know, but I would happily come back if it's sometime before October. So
Well, thanks again. And I mean this very sincerely. I wish you well with the upcoming work that you're going to have to be shouldering. It's not an easy task for anybody to take on.
thank you. And good luck to all of you as you continue to educate people. And thank you for doing these webinars each week. I think they're extremely useful.
Great. Thanks.
Thank you, Referee Houghtaling. And just a reminder, we are doing another session. We're going to kind of probably start to combine our sessions each week just to do them on Wednesdays. And next week, we're going to be covering the new executive order. A reminder, you will get an email after today's session with a link to the recording, and we will put up the slides as well on our website once the recording is ready. So thanks again, everybody, for participating.